You know, from your phone plan to the coffee you bought this morning, you're actually making contracts all the time. But what really turns a simple promise into something the law will enforce? It's not magic, but it kind of does have a secret recipe. So, what's in that recipe? Let's dig in.
Come on, we've all done it. The pinky swear. It feels serious, right? It's this solemn promise. But could you actually sue someone for breaking one? I know it sounds a little silly, but this question gets right to the heart of what the law considers a real binding deal.
Okay, so here's the crucial thing. A contract is way more than just a promise. It's a very specific type of promise, one that the legal system will actually stand behind. Unlike that pinky swear with your friend, a contract has special ingredients that give it real legal muscle. So how does a simple promise level up and get that legal muscle we were just talking about? Well, it has to pass a pretty important test. The law is looking for a genuine, two-way bargain where both sides are seriously actually committing to a deal. At its very core, a binding promise really rests on two big ideas. First, there has to be what lawyers call a meeting of the minds. This just means both people have to genuinely intend to create a legally binding agreement. And second, there's got to be an exchange of value. A promise can't just be a one-way street. It has to be bought by something of value from the other side. And that something can even be just another promise. So how do we get there? Well, lucky for us, contract law gives us a pretty clear three-step recipe. These are the fundamental building blocks you're going to find in pretty much every single valid contract. Let's break this down with a quick example. Let's say Alex wants a new shed. Builder Bob gives Alex a quote to build it for a specific price. That right there, that's the offer. Alex signs the quote, agreeing to all the terms. That's the acceptance. And finally, Alex agrees to pay Bob in exchange for him building the shed. That exchange, the work for the money, is the consideration. Offer, acceptance, consideration. Boom, you've got yourself a contract. Okay, but here's where it gets a little tricky. A subtle but really vital distinction the law makes. Not every proposal is a true offer. For instance, a price tag on a sweater in a shop window. You might think that's an offer to sell, but legally, it's what's called an invitation to treat. It's basically inviting you to make an offer to buy it, which the shopkeeper can then either accept or reject. And offers can get, well, they can get pretty weird. There's this famous old case, Carliver Carbolic Smokeball Co., where a company ran an ad promising a 100-pound reward to anyone who used their product and still got the flu. The court said this wasn't just some marketing gimmick. It was a serious offer made to the entire world. So when Mrs. Carlill used the smokeball, got sick, and claimed her money, she had accepted the offer just by doing the act. This created a unilateral contract, a deal where acceptance isn't a signature, but an action. So what about that exchange of value, the consideration? Now, get this. It doesn't have to be fair. It doesn't even have to make a ton of sense. In one wild case, Nestle offered a record in exchange for a small payment plus 3 chocolate wrappers. And the court decided that those technically worthless wrappers were still part of the deal. The key is that something of economic value, no matter how tiny, was exchanged. Okay, so you've got a contract. Awesome. But the real devil is often hiding in the details. The terms of the agreement. And this, my friends, is where you have to be really, really careful. This is honestly one of the harshest, but also one of the clearest rules in all of contract law. If you put your signature on a document, the law assumes you have read it, you have understood it, and you have agreed to every single word in it. No excuses. And this case is the perfect, if painful, example of why. A woman bought a vending machine that, well, it just didn't work. But buried in the contract she signed was a clause in what the court itself called regrettably small print that removed all liability from the seller. And because she signed it, she was stuck. The machine was broken, and she had no legal way to get her money back. A very tough lesson to learn. But what happens if the problem isn't the fine print, but one person just doesn't do what they promised? Well, in legal terms, this is called a breach of contract. So the law makes a really big distinction here. If someone breaks a condition, that's a major term that goes to the very heart of the contract, that is serious. It lets the wronged party just walk away from the whole deal and sue for damages. But breaking a warranty, that's a minor, less important term, only lets you sue for damages. You can't just end the entire contract over it. Let's go back to Alex and Bob's shed. Remember, they specifically agreed on cedar wood. That's not just some minor detail, that's a condition of the contract. It's fundamental. So when Bob uses cheap pine instead, he's breached a core part of the deal. Alex now has the power to terminate the whole contract, refuse to pay, and even sue Bob for any losses. All right, so we know you can get out of a contract if there's a major breach. But what if the contract was technically formed correctly, but the way it was formed was, well, fundamentally unfair?
Luckily, the law provides a few, let's call them escape hatches, for situations where there wasn't genuine consent. These are things that can make an otherwise perfectly valid contract voidable, which just means the wronged party gets to choose to cancel it. Dress is a big one, and we're not just talking about physical threats here. In the case of Atlas Express v. Kafko, a shipping company basically threatened to stop all deliveries for a small business unless they agreed to pay more. Since not getting those deliveries would have destroyed the small company's massive contract with a client, the courts said they only agreed under economic duress, and the new higher price wasn't enforceable. Misrepresentation is all about being tricked into a deal by a false statement. And this is where it gets really interesting, because even silence can count as a misrepresentation. In one case, a doctor was selling his medical practice and stated it was worth a certain amount. But before the contract was signed, the doctor got sick and lost most of his patients, making the practice nearly worthless. His failure to correct his earlier statement, to speak up and say, hey, things have changed, was a misrepresentation.
So let's pack our contract toolkit. What are the key takeaways? First, remember the chocolate wrappers. A deal needs an exchange of value, a consideration, no matter how small. Second, think of that woman and the broken vending machine. The law is absolutely ruthless about your signature, so please read the fine print. And finally, remember Bob's pine shed. Knowing the difference between a core promise, a condition, and a minor one, a warranty, is your key to understanding your rights when a deal goes south.
Which brings us to our final thought. The whole point of contract law is to build a system of clear rules to make business predictable and certain. But as we saw with the woman who signed for the broken machine, those rigid rules can sometimes lead to outcomes that just don't feel entirely fair. And that tension, right there, between certainty and fairness, is what makes contract law so endlessly fascinating.